Okay, my clock says it's 7:30, so let's get started. Welcome everyone to our Dressage for Kids unmounted program, D4K Up as we call it. A huge thank you to Susan Sieber and Carol Baker, who do so much to help organize these programs, helping our executive director, Mary Livernoir. And of course, thank you to the Connecticut Dressage Association for their financial support of D4K Up. And a huge thank you to Trafalgar Square Books for their sponsorship. They've been sponsoring D4K since the very beginning, about 25, 26 years ago. And they will be giving gift cards. They have been giving gift cards during our series, and we will have a drawing just before we get started tonight for a $25 gift card. Our next up Zoom meeting is April 28th with Dr. Allison Arnold from Head Games for a presentation on mental toughness and dressage, turning setbacks into setups for success. And of course, do go to our Dressage for Kids website to check the calendar for various other activities that are going on. We will have questions only at the end. Feel free as we're going to write questions in the chat, and then at the end we'll catch up with anything that hasn't been covered. We're very excited to have, very lucky to have tonight Barbara Richardson of counsel of the West Palm Beach office of Schultz and Bowen LLP, where she's a member of the real estate and equine law practice groups. In her real estate practice, she works with residential, commercial, and farm property owners and title insurance companies in connection with real estate transactions and farm improvements. In addition to the real estate practice, Barbara is an active equestrian and understands the decisions her clients make when launching and operating various types of equine businesses. She's experienced in negotiating, preparing documentation that our clients need, including things such as liability releases, sale and purchase agreements, bills of sale, board and trading agreements, equine lease agreements, equine consignment agreements, farm stable and residential sale and purchase agreements, farm stable and residential lease agreements. Did we know there was so much we had to worry about in our business? You're going to find out about it now. So I turn you over to Barbara.
Good evening, everybody, and I apologize that you can't see me. I had to work remotely today due to a dog emergency, and I'm having a little trouble with my computer at home, so bear with me. Thank you, Lyndon and Mary, for inviting me to speak tonight, and thank you to everyone who is joining us. When Lyndon and Mary invited me to speak, I inquired about the group and what the constituents might be interested in hearing. It seems your group has people from all areas of the equine industry, and in approximately 22 different states, so it's quite diverse. The most popular topic was liability. So I'd like to address the different ways we can manage the risks of financial liability in our industry through A, contracts, B, releases and the Equine Activity Liability Acts, and C, insurance. My talk is probably going to be pretty basic due to the diversity of your group, but hopefully everyone will learn some helpful information. Just a few words about how I became an equine attorney. I began my legal career as a litigator, and while litigation is in some instances a necessary evil, I soon viewed it as a test of time and money, with many litigants abusing the judicial system and many times for the wrong reasons. So I changed the focus of my practice to real estate transactional work with the goal of structuring transactions and other documents to address situations up front that I'd seen in litigation give rise to disputes, and hopefully be able to prevent it through good drafting, or at least make disputes easier to resolve. Years later, maybe 20 years ago, I started riding and became aware of the types of disputes that arose in the horse industry with trainers, agent commissions, sale and lease transactions, owners sending horses to agents for sale, owner-rider sponsorships was a big one, boarding arrangements, and issues between boarders, to name a few. Many of those disputes could have been prevented, or at least, again, more easily resolved had the parties stated their expectations of each other and their respective obligations and liabilities in a written contract. So I'll start talking about the contracts. I would ideally like to discuss a variety of contracts individually, but since we have time constraints this evening, I will go through a list of provisions that I recommend people consider putting in your agreements, with several examples of where they might be most fitting. Number one, it's important to have a document that's clear, specific, unambiguous, signed and dated by all parties to a transaction. And while not all agreements need to be in writing to be enforceable, having a signed document can save a lot of time and money if the transaction ever goes south and attorneys, mediators, arbitrators, judges, or juries ever need to be called upon to resolve a dispute. So imagine having to give any one of these fact finders days, months, or years worth of texts and emails and relaying phone and other conversations that are part of the transaction. And consider the time and expense of having to send all that to opposing counsel. We have to hire forensics investigators to extract information from phones. And it is, it's very hard for a fact finder to put together all of that. And I actually had that happen. Somebody came to me with a breeding agreement. She said she had, 3 years worth of texts, and there were 5 different transactions. And I told her it would be, for her to pay an attorney to go through all this, she could have saved money up front, just spending a couple of $1,000s and having it done, neatly. And a good rule of thumb in contract drafting is to ask yourself, what is the intention of the parties? Buyers, seller, agents, trainers, boarders, sponsors, riders, service providers. And what about the relationship between the parties and the intentions? And what about the transaction could possibly give rise to question or dispute down the road? And then you create a provision to deal with it. So it's kind of like saying, what if? So you're going to lease a horse, and okay, so you get a lease price for the horse, for the year, for the 6 months, whatever. Well, what if the horse dies? What if the horse becomes, unable to do the work for which he was leased? And try to have an agreement. Well, you can bring the horse back, or you're responsible for the horse anyway. But if you kind of look ahead to see what could possibly happen, it just lends to good drafting, so that the agreement becomes a roadmap for your relationship. Another thing you have to put in the contract is the parties. And that might seem very obvious to say, that the parties should be specifically identified. But sometimes people are mentioned in contracts whose role isn't clear. For example, I just had someone named in a purchase and sale agreement for a horse, and there wasn't a clear statement that she was an agent for the seller. So the buyer, who now wants to rescind the contract, considers this person to be a co-owner, because the contract doesn't say what they are, and joins this poor person as a defendant in the lawsuit. So now this poor trainer has to spend a lot of time and money to be dismissed. So in addition to the main parties to a contract, if there are other people who have any obligations, they should also be named and defined. For example, a trainer in a horse lease situation might undertake to provide certain services to the horse or to the lessee. So you want to have them be a party to the agreement, so that the owner of the horse knows that this horse and this lessee are going to get the care and the services that is part of the transaction with the lessee. Also, an agent in a sale and purchase transaction who undertakes to handle funds on behalf of the seller, they should also be a party to the contract to hold them accountable and liable. Okay, communications between the parties. That's another thing to consider in drafting your agreements. And there should always be a formal notice provision with each party's full name, address, phone number, and email address. And that might also seem obvious, but In the event there's some notice, like in the lease of a horse, the owner wants to know if a medical condition comes up, how is that lessee going to notify, the owner? If there's a dispute, what notices they're going to be? If you have an option to purchase the horse, what notice has to be given to tell the owner that you're going to exercise the option or not? And also the communications, the manner in which communication should be delivered should be stated clearly in the contract. So if you want it in writing, delivered by overnight courier and or by hand and or by email. And you can also include parties to whom copies should be sent. Sometimes a party's attorney, you might want them to get notice of a default or whatnot. Next on my list for provisions is monetary payments. And this could be the purchase price, lease price for a horse, boarding or training fees, charges for extra services or products, commissions for the sale or lease of a horse, insurance premiums for a leased horse or for a pre-purchase trial agreement, transportation charges, etc. And amounts should be specified as much as possible. And sometimes if you can't specify an amount, I recommend including a calculation for determining that amount. Or sometimes you can have a schedule that you attach to an agreement that could be, in a lease or boarding agreement, a training agreement. That way you can still use your form agreement and just change the schedule with different prices when they go up, or you're going to add them or whatnot. So there should also be a clear indication of when payment is due, how payment will be accepted, and where it must be remitted. Are you going to take checks? Do you take cash and give a receipt? Do you want it wire transferred? And each transaction is different depending on the amount involved and who you're dealing with. And whether or not you want to have a grace period. Are you going to allow 5 days without a penalty for a boarding agreement or a training agreement? Also, this comes up a lot in my practice. It should be clearly stated whether any payments are non-refundable or prorated and returned under certain circumstances, such as we were saying before about the return of a portion of a lease price if a horse dies or the lease is terminated for one of the reasons you might include in the lease agreement. This is also important in boarding agreements. And maybe if you have groom's quarters or a residence you're leasing on your farm, whether the money's paid in advance for reserving are refundable or not. We see that a lot. People put down a deposit to hold stalls. Something happens to the horse up north. They don't come down. They want their deposit back. One person thinks it should be refundable. The other person doesn't. And again, it costs a lot more time and money to try and argue back and forth than if you just had it stated clearly in the agreement in the first instance. So another important aspect I see in risk mitigation is due diligence, inspection periods, and disclosures. And these are very hot topics in sale and purchase and lease transactions, pre-purchase trial agreements, and situations where an owner sends a horse to an agent for sale, a consignment arrangement. So from a seller's or lessor's perspective, you want to put as much responsibility on the buyer or the lessee to conduct their own investigations, examinations, and research. So you can have them represent and warrant in any agreement that they are buying or leasing the horse based solely on their own determination that the horse is suitable for their purpose. And specifically that they're not relying on in any way on anything the seller or the lessor or their agents may say. And here are some things I advise a client to do to this end, and not all clients like it, but in my view, from a legal perspective, it's for the benefit of both the buyer and the seller, and for the lessee and the lessor. So the first thing I would do is have the buyer and lessee represent and warrant that they have conducted their own sufficient pre-purchase exam, they research show records, they researched pedigrees, really important in breeding agreements. They've had blood work, they've had sufficient trial of the horse so that there's, it's just their own determination with their trainer or whoever else is making the decision. The second thing would be to give the buyer or the lessee all the horse's medical records to review. And how many times have I seen clients roll their eyes at me and I say, well, you run the risk of being accused later of failing to disclose something that the buyer or the lessee considered a material fact that had they known, they wouldn't have bought or leased the horse, and then they seek to rescind the transaction. So, you may not want to tell the buyer that there was a check ligament problem or a bone chip was removed or, there was a suspensory injury. But it's better to lose the sale or lose the lease than have the buyer come back later trying to rescind the transaction because you weren't honest with them. The next one is to have the buyer or the lessee state their intended purpose for the horse. Like they want an amateur-friendly third-level dressage horse. They want a meter 30 jumper. They want an FEI Grand Prix dressage horse. And then have them represent and warrant that the horse is suitable for that purpose based on their own due diligence. I would always recommend avoiding saying, yeah, the horse will be capable of doing passage and piaffe, and the horse will be capable of jumping a meter 50, because there's never a guarantee, no matter how talented the horse is or what the bloodlines are, that horse is going to perform. So I tell people to avoid making any comment about what the horse might be able to do. Stick to the facts. What has the horse done? The next thing is be careful what is posted on social media and on sales sites about the horse. Sometimes people come back and say, well, you had the horse doing this or you had the horse doing that, and you didn't tell me this or that. And it's just a good rule of thumb to monitor what's posted. Next one is disclose surgeries that the horse has had. It's important to know whether the horse is colicked or not, and put yourself in the buyer's or the lessee's position. Would you, as a reasonable person, buy or lease that horse if you knew it had blank? If it had colic surgeries, if it had melanomas, if it had, kissing spine, whatever it is that your horse has, would you think that's objectionable? And it's best to err on the side of disclosing it. In the same vein, I recommend disclosing treatments that the horse receives on a regular basis. Now, you might consider certain treatments to be routine maintenance. I had a case recently with injections. The horse was getting injections and coffin bone and hocks and all fetlock on a routine basis. And this wasn't disclosed. And the seller thought, well, everybody does that, or it's just maintenance. And the buyer considered it to be a material fact because they didn't want the expense and they didn't want a horse that they thought really needed this and maybe had a potential for breaking down. And the buyer was successful in getting the sale rescinded. So again, better to lose the sale or the lease than have them come back at you later. Same thing with major injuries. Again, a buyer or lessee might consider them material and you may or may not. Another thing to disclose is behaviors that may or may not be objectionable. And again, it's better to err on the side of disclosure to avoid a possible claim for rescission later. And such behaviors could be cribbing, weaving, holdback syndrome, aversion to horses coming head on, kicking if other horses get too close, aversion to a whip. So you should say that. And again, I can't stress enough to avoid opinions about a horse, what might be able to do. Stick to the facts of what the horse has done. On that note, for an agent who takes a horse on consignment, I recommend that they ask the horse's owner for the horse's medical records and all the representations we just talked about. Has the horse had surgeries? What treatments does the horse get? Injuries? What behaviors would the horse have that might be, something a reasonable person may want to know. And this information should be disclosed, I believe, in writing to the agent. If I was the agent, I would always require a written consignment agreement with those representations. Because if the horse has an aversion to other horses coming at it, and that's not disclosed by the owner to the agent, and then someone comes to try the horse, and they ask, does he have any bad behaviors? What, blah, blah, blah. And agent doesn't know. Agent has the horse a couple of weeks. No problems that I've seen. Well, they bring the horse to a show to try the horse, see what he's like on another, in another venue. And when horses come at the horse, he bolts, he bucks, he runs, and he throws the rider into a fence. It turns out the owner knew this and didn't disclose it. The trainer got involved in the lawsuit because then the person that tried the horse and got hurt said, you didn't tell me. And well, had the agent, gotten all that information from the owner, they could have answered the questions the buyer was asking honestly, and B, it would have saved them from being joined in a lawsuit. So, in many cases, agents are made defendants in lawsuits, and I guess it's to put pressure on people and, put the frogs in the oil and see who can climb out above. So anyway, as an aside, while we're talking about due diligence and pre-purchase inspections, I'd like to address the distinction between a purchase and sale agreement and a bill of sale. And I see this a lot, where someone comes to me with a bill of sale and a purchase agreement, but something happened and it didn't go through. Well, the bill of sale part of it purports to convey title to the horse. So if there are contingencies, you don't want to have the two documents in one. So this is similar to real estate transactions where you have two situations. First, you can enter into a contract for sale and purchase that requires a deposit and contains a contingency for inspections. And then if the inspections are satisfactory to the buyer, then the transaction closes. For real estate, the seller gives the buyer a deed. For a horse, the seller gives the buyer a bill of sale. And note that the bill of sale should incorporate the contract representations and warranties. And in Florida, this is required by administrative rule. So I don't know if a lot of states have legislation governing the purchase and sale of horses, but Florida has a statute that enabled administrative promulgation of rules that were a little more specific about what must be included in a bill of sale, what must be disclosed to buyers if they ask, and also disclosure of commissions being paid in agency transactions. So again, if you have a sale of a horse that's contingent upon vet inspections, blood results, anything like that, you don't want to call that document a bill of sale. So you need two separate documents, and that's my opinion. That's my view. Other people might feel differently, but I just think it's cleaner to have two and avoid any ambiguity. So the second situation is when you do have a buyer that's determined to close after the inspections are complete, and you can go right to closing. So in that situation, you could have something you call a purchase and sale agreement and bill of sale, and have all your representations, everything about the horse and purchase price and whatnot, and call it a bill of sale, and that document would convey title to the horse. Now, one other reason I think it's a good idea to have two separate documents is sometimes you don't want other people seeing the terms of your sale and purchase agreement. In some we have confidentiality clauses. Some famous person buys a horse and they don't want everybody knowing their deal. And once the horse is bought, if that contract is also the bill of sale, you might have to present it to, a buyer somewhere down the line if they ask for proof that you own the horse, or giving it to USEF or the Dressage Federation or wherever other governing body that needs to see proof that you own the horse. So confidentiality is another consideration. And again, some states do have statutory regulations, so you should always check and see what your state requires. Okay, so moving on to other contract provisions, and this is another one in dealing with risk management, is warnings. Boarding contracts, training agreements, leases, consignment agreements, again, pre-purchase trial agreements, and contracts for sale and purchase should contain a warning that may be required by your state's Equine Activity Liability Act. And I'm kind of getting ahead of myself talking about the liability acts, but it's important to comply with their requirements in order to claim the benefit of the immunity that the acts provide. 48 states have Equine Activity Liability Acts, and some have statutes that not only apply to horses, but they apply to farm animals and or domestic animals and or livestock. California and Maryland are the only two states that do not have some form of Equine Activity Liability Act. And I guess those states just go on the common law. So many of these liability acts require warning signs be posted in certain locations on the property that are used for equestrian or farm purposes. Like, for example, in my state, Florida, we have to have signs with a certain size print, certain color in bold, and the statutory language. And in Florida, and I assume other states, they require that an equine activity sponsor or equine professional, as the acts define those terms, and that could be another hour of discussion, just talking about the definitions in the acts. But like in Florida, the law also requires that the person who comes on the property, the participant, be given a written document which the participant shall sign with the warning clearly printed on it. So again, someone comes to your property to try a horse, you should have a separate release and something with that warning clearly printed on it. It should be in your boarding agreements, training agreements, and just in order to comply with the law. And again, be assured that you've done everything possible to get the benefit of the immunity that the act provides. So then we move on to insurance. And a lot of people think they don't need to have insurance, or they don't need to have liability releases because of the Equine Activity Liability Act. And well, the acts don't provide immunity from all types of injury, and I'll get to that. But right now, farm owners should always have an equine and farm comprehensive liability insurance policy, with hands down. And again, a lot of people think they don't need it, but it's something that I recommend everybody have. Now, there are a variety of other insurance policies that you can require another party to certain agreements to obtain for your protection as well as theirs. So in a boarding situation, first, trainers who lease stalls or just come onto the property to teach should have trainers liability insurance, naming you as the farm owner as an additional insured. And this gives coverage for liability for injury, accidents, and damage to persons and property. Second, anyone on your property who cares for horses that are owned by other people. So you lease to a trainer, they sublease to their clients, and they are taking care of horses that they don't own. they should have policies for care, custody, and control insurance, and also naming you as the farm owner as an additional insured. So this provides coverage for injury and theft to horses that are in that person's care. And, you know, if something hurts a horse, everyone's going to get sued, the trainer, property owner, and as a farm owner, your insurance carrier is going to be very happy to see that you required them to have all this insurance. Third, horse owners on your property should have their own equine liability insurance, naming you again as an additional insured. And this is for coverage for injury caused by their horses. So their horse kicks someone else, injures them, there's insurance to go after. And again, you can have all the liability releases and indemnifications and hold harmless agreements. And at the end of the day, everyone's going to get sued anyway. And the insurance is very, very important to have. Now, this is one you really can't require or don't require, but I always put in my agreements that people who maybe board horses on your property should be encouraged to have mortality and major medical insurance for their horses and insurance for the loss and theft of their personal property, which would include horses. At least in Florida, horses are considered personal property. You can't get an award for pain and suffering if, you know, the loss of a horse or the injury for a horse because they're quote unquote goods under the Uniform Commercial Code. So it's a good idea to tell people, make them aware they should have that insurance. So in lease and pre-purchase trial agreements, the types of insurance you should require are equine mortality and major medical. And I recommend that the owner of the horse take out the policy and make the lessee or the buyer pay the premium. That way you have control over the insurance. You are the one who's going to get paid. It's just a lot cleaner to make sure you have the insurance. It's easier to collect the money than maybe you even get proof that the other person bought the insurance they're supposed to have, but then you don't get notice of cancellation, or they don't make the claim on time and coverage is denied. So I don't know, I'd like to have my clients have as much control over their situations as possible. And the other thing in lease and pre-purchase trial agreements is the equine liability insurance we just talked about. And again, I recommend that the horse owner maintain it and have the lessee or the buyer pay the premium. Now, for the lease of a farm, you know, I have clients who lease their farms to trainers or people who not only board there, but live on the property. And you should require all of the other insurances and also make sure that they have their own general liability insurance, naming the farm owner as an additional insured. I can't stress that enough. So in talking about insurance, I know we mentioned indemnification and hold harmless agreements. So agreements for boarding, training, consignment, leases, pre-purchase trials, they should, I believe they should include indemnification and hold harmless agreements by your lessee or whoever has control of the horse for any injury to person, property, or horses that occurs on the property. Now, again, you know, they say, well, why do we need that? We have an equine activity liability statute. If anyone gets hurt, well, the act will give me immunity. And no, that's not the case. And there are exceptions to the Equine Activity Liability Acts that as a matter of contract, you can have someone agree to take the responsibility for. So that leads us to releases and waivers. And again, I can't stress enough that this is one of the biggest things in risk management that people should have. If they have nothing else, I tell them they should have a good liability release. And if you should have it in your favor. So anyone coming on your property to ride a horse, be around horses, even spectators should be required to sign a release. people roll their eyes. How can I ask everyone to sign? Well, for one example, a spectator in Florida is not covered by the Equine Activity Liability Act unless they put themselves in an unauthorized area where the horses are. So a spectator is sitting, watching granddaughter ride by the arena. Horse gets loose, horse hurts the grandmother. Well, she's not a participant that the act covers, so you can be held liable to the grandmother's injuries. If the grandmother puts herself in the barn, which should be unauthorized for her to be in, then she becomes a participant under the Florida Act and the immunity will apply. So, why take the risk? Just have people sign a release. So as a matter of contract, they are agreeing to waive a cause of action and lawsuit against you for any injury they might suffer while on your property. Now, when you have farm leases, say you're leasing your farm to a trainer or other people, and they have people come on the property. So you get them in farm leases and boarding agreements, training agreements. I always attach the liability release as an exhibit and have them sign it. So there's no question, that they understand they have to do that. But in addition to that, I require that they, the trainer, the owner, that they are responsible to have people who come on to the property to maybe try their horse or, just be a spectator, that they are also have to sign your liability release. And any trainer should have their own liability release. So you could be asking people to sign 2 different releases. But it's again, your insurance company is going to be very happy when a claim is made and you have a boarding agreement, training agreement with the indemnification and the hold harmless, and you have an insurance policy and you have a written release. And I can't tell you how many people, have been, gotten off the hook because they had every protection in place. So again, let's see. I'm going through my notes. I kind of got ahead of myself. Bear with me. Okay. Talking about the Equine Activity Liability Acts and complying with the requirements. Again, not all loss or injury that can occur on a farm or incident to riding horses or participating are covered by the acts. So immunity under the acts is only afforded for risks that are inherent to participating in equine activities. And that's what the Florida statute says. And I assume most other state statutes have that type of provision. And again, you could spend a whole hour talking about just the different terms that the acts define. So there are a lot of things that could happen on your property that are not equine activities, although associated with horses. They're not equine activities that the act would grant you immunity from. So examples of some of the risks that we want people to release are dogs. Dogs and horses go together, don't they? Well, not when that's an Australian Shepherd and it gets loose and it runs and is trying to herd the horses in the paddock and they slip and fall and break a hip. And you get sued maybe for allowing the dog to be running loose on the property. And the act will not apply to afford you immunity from that lawsuit. So again, in a release, I would say, I would add dogs and other animals and accidents that happen from horses, being spooked by a dog, or golf carts, bicycles, scooters, other vehicles. Those aren't covered by the act. Good one is failure to wear a helmet. And there are a few laws that say you have to wear a helmet when mounted on a horse. But if you require somebody to do that, and they get hurt, it's a good idea to have that risk defined in your liability release, so they are aware of what the risk is, and that they're assuming the risk by coming on your property and doing what they do. Again, failure to wear boots and closed-toe shoes. It sounds very, innocuous, but I think it's a good precaution to take. You could put those in barn rules too. Another good one, especially here in Wellington, is distraction by the use of a cell phone while mounted on a horse. How many kids do you see, like even trail riding or in an arena, and they're on a cell phone? Well, that's something that's their own negligence, but again, they should be made aware of the risk. And I've had people put in their barn rules that you're not allowed to use a cell phone when you're, on a horse, or you run the risk of getting hurt because you were not paying attention. And you could have, a reasonable person wouldn't have done that. Okay. So there are certain exceptions in Equine Activity Liability Acts that, at least in Florida, the exceptions are if you as a provider of a horse, maybe for someone to try, or you have a boarding stable, or someone's taking a lesson on one of your horses, or even one of your clients' horses, that if you provide tack that you knew or should have known was faulty, and the injury is sustained because of that cause, you are not immune from liability under the Act. Another exception would be if you provide a horse to someone to ride, and you failed to make reasonable efforts to determine the ability of that rider to engage safely in equine activity. And that's a tough one. Like, you ask somebody, well, how well do you ride? What level? Oh, I ride Grand Prix. We hear that all the time, right? And then the person gets on the horse and she can't do a second level test. So you've done your due diligence to try to, find out, but you do have to do that due diligence, because if they get an injury and they say you gave them a horse that overfaced them, they're going to claim that that exception to the Act does not provide you with immunity, and a lawsuit could be successfully brought against you. Failure to post warning signs to make participants aware of a dangerous condition on your property. So if you know that there's, a ditch that was maybe full of water because you had the 100-year rain, and there was certain erosion that would be a dangerous place for a horse to be in either a paddock or an arena or trail. If you don't post a warning on that and an injury occurs, you're liable. So I always counsel clients, walk the property a couple of times a week, see what, might be there, that you put a cone up, or fix it right away. I always say, fix it right away. Why take the risk? You can avoid the risk very easily. And then we come to negligence and gross negligence. And in Florida, one of the exceptions that is in the Act is if you, as the equine sponsor, commits an act that a reasonable person would not have done or omitted to do under the circumstances, and it was in disregard for the safety of the participant, then you will not be afforded the immunity from the Act, and you could be successfully sued and held liable. And it goes without saying that gross negligence or willful, what they call wanton disregard for the safety of the participant, is also an exception under the Act. So while we're talking about releases and waivers, there are two situations that I would say warrant discussion, or at least something for you to be thinking about. One is the waiver of the rights of a minor child, and the second one is liability for giving remote lessons or clinics. So someone's in another state and you're here in Florida, but your student is still back in Massachusetts and you're doing everything by video. what state's liability law applies. Does Florida apply or does Massachusetts apply? And in that instance, the best advice I could give is to have the person you're giving the lesson to sign your liability release with specific indications of what the risks are of having you be in one state and them being in another. And by those risks, I mean, you're not there to check the tack. Maybe the curb chain is too tight. Maybe the saddle is, the girth is loose. You're not checking the client. You can't see that a tractor is coming that might spook the horse, that you could give your rider some guidance to, get out of danger's way or stop the lesson, or, and with technology being what it is, it's great. I mean, it's great that you can give, remote lessons, but you as a trainer can't see everything that's going on. You may not be able to hear what the horse is maybe breathing, or the rider. So there's a lot you can't glean, and you should put that as a risk in the trainer's liability release. Technology is great, but it doesn't afford you the full view and access to the horse and rider, the surrounding circumstances, and the tack and the equipment. So then that brings me to waiving the rights of a minor. So you should check your state statutes to determine who has the authority to release the rights of a minor child, and whether the statute dictates any language that must be included in a written release. Some statutes may also restrict the matters that can or cannot be waived. In Florida, parents are natural guardians of their minor children, and they do have the authority to waive the rights of their minor children under certain circumstances. For the purpose of our discussion, Florida allows a parent to release the claims against a commercial activity provider for injury or death and property damage resulting from an inherent risk in the activity. Now, they don't specify equine activity, it could be any activity. It could be, some kind of sports, a trampoline park, whatever. But unfortunately, the Florida law doesn't define what is a commercial activity provider. So you're giving lessons to a minor child and you're doing it for money. Well, does that make you a commercial activity provider? It's arguable that it could. And if that is possible, then the release, at least in Florida, has to contain a very, very, I think, I don't want to say overbearing, but it's a very long, I think, statement that you have to have verbatim in a certain size with certain line spacing. I mean, I had to read it 3 times before I said, really? Like, I have to put this in my releases. But if you don't, then you don't get the immunity of that release. They could hold the release to be invalid because you did not give the parent enough warning of the risks of what you are having them waive on behalf of a minor child. So in abundance of caution, releases in Florida, at least, that are executed on behalf of minor children should contain the statutory warning, whether you think you're a commercial activity provider or not. And note that the Florida statute doesn't limit the ability of a parent to waive claims against a non-commercial activity provider to the extent authorized by common law, but it doesn't say what a non-commercial activity provider is. So it's the opposite of a commercial activity provider, but what's that? So in any event, I would always recommend having the language. It's better to have too much than too little. Now, another one that comes up is there are times when a parent is not available to sign a release. And maybe another relative or a trainer brings a child to try a horse, brings them. And I would strongly, strongly suggest that you require a parent to sign the release in advance. It could be signed electronically if need be. And, oftentimes people will say, well, that's so impractical. The horse is at the show and the kid is there, and, it's an emotional thing and they're looking for that equitation horse. And so it's very spontaneous that the child wants to try the horse. Of course, the trainer wants the child to try the horse. The seller of the horse wants the child to try the horse, but parent is nowhere around to sign a release. Nobody has a release with them. They run a risk. So it's unclear whether or not a parent can delegate their authority to waive anything on behalf of a minor child. I haven't come across anything that says, well, in some cases we say, okay, give the trainer a power of attorney and make the trainer say, yes, I am authorized. I take full responsibility. Parent authorized me. I don't know if that's ever going to hold up in court, but sometimes you have to take that chance and hope that nothing happens. But, it's easy enough to have a parent sign a release if they're going to sign a power of attorney. Unless the power of attorney is for, maybe, the child comes down with the trainer for a week or two to try horses, in that instance, but someone still has to sign the release. So that's my best recommendation as far as having releases. And that's about all I have. So any questions? I haven't been looking at the chat.
Yes, we do have a couple questions.
I hope your dog is okay. Thank you so much. Yes, the dog is okay. He's gonna live. He got a laceration in his eye and had to go to the ophthalmologist. They had to debridle it. But thank you.
So one of the questions is regarding clauses in boarding contracts that state that a business will own a horse if a month or two of board is not paid.
That's
How?
that's a good question. And that is something that will depend on your state's laws. I can tell you in Florida, if you are boarding horses and they do not pay the board, you have what we call a statutory stableman's lien on the horse. And the lien, the statute provides that the owner who's providing the care and the board for the horse has a lien on the horse and can hold possession of the horse and sell the horse if the money is not paid. Now you have to file a notice of claim of lien, and there are statutory provisions for having, a sale, a public sale. And it doesn't say in Florida, at least, that you can own the horse. I mean, you'd have to go through the statutory provision for filing the claim of lien and then obtaining title to the horse. And then from the purchase price that you may sell the horse for at that sale, the boarding person can only keep the money they are owed. Now, there's no such lien for trainers, for training. So if you own a farm, you're a trainer, and you have a boarding and training agreement, and you're providing both, and your boarder student doesn't pay you, you only have a lien statutorily for the amount of they owe you for the care and board of the horse. Now, maybe in a training agreement, you can create that lien and have the person agree that you have a lien for anything they owe you, and on their personal property as well as, the horse. So there's a lot you can put in a written agreement. Enforcing it's another thing, but at least you have it in writing and they agree to it. So I think that answers that question.
Okay. Do you feel that personal injury policies are valuable as backup plans for professionals who could potentially get hurt? And also, do you have any recommendations on like where to get good information and how to get started on that?
Is that meaning when you say a personal injury policy, you mean your own liability insurance? What, I'm not sure what they're getting at there. Maybe I'm not reading the right. Okay, I think I see it. It's Abigail's chat.
Yes.
Is that what you're referring to?
Yep, the second question.
A personal injury policy. Well, I think if I understand that right, a trainer's policy of insurance would provide certain medical insurance. So if the professional gets hurt, or if the student gets hurt, if anyone gets hurt, it depends on your policy. And I assume that different insurers offer different types of policy with different coverage amounts. So if you could just Google equine trainers liability insurance, and maybe Markel, Great American. A lot of insurance companies will have something online. They even have applications online, and it's not very expensive. I mean, it could cost $800, $900, maybe $1,000 a year to have a good policy. And again, you have to talk to them about your deductibles and the coverage amounts, because that's all, variable. But I always recommend it. I had a farm owner who had a trainer. She allowed trainers to come on their property who didn't have trainers insurance. And the trainer tells the student to do something that no reasonable trainer would ever tell a student to do. So it was clearly like malpractice. It was clearly not within the standard of care of what a dressage trainer should or shouldn't do. Person fell off the horse, broke her hips. It was a nightmare. So the trainer didn't have insurance. So who got sued? The owner of the farm. And if she had had, a good liability policy, then that would have hopefully kicked in, and the insurance company would at least, pay for the defense. But the trainer should have had their own insurance too. And even if you have the trainer have insurance, that doesn't mean you're all not going to get sued, because people are just going to try to sue anyway. And unfortunately, they find lawyers who will take certain cases that have no merit, but we call them nuisance lawsuits. It's better to pay me $10,000 to make me go away than have you spend money on your lawyer fighting it. So hopefully that answers that question.
Okay. We're almost out of time, so I think we're just going to cover one or two more really quickly.
Okay.
How do you, the free online equine industry contracts, are any of those worth looking into, or?
Well, I would hesitate to use anything online. First of all, if it's free, it may not cover everything that you need covered. And as a lawyer, I'm very detailed. I like to tailor every agreement to my particular client, like a client having a lease agreement for a horse. They may say, well, I know the person who's taking the horse and it's not one of my best horses, and okay, it's just best to get the horse off my payroll, and they really don't want that much control over the horse. Where someone else is going to say, I just spent $500,000 on that jumper. I want control over who shoes him, who treats him medically. I want control over his dentist. I want to know the vaccinations are made, so there's a lot more detail. And I really can't say what's free online because I haven't really looked, I mean, every once in a while a client might refer me to something, and there are so many provisions it doesn't have. It may not have an attorney's fees provision. Say in Florida, you can't get an award of attorney's fees if it's not in writing, in an agreement between the two parties, or it's by statute. So people say, well, I can sue them, I'll get my fees. And I look at the agreement and say, no, you're not. So there are different things in different states that should or shouldn't be in there that you can or cannot agree to. So I would never recommend, using something online. And if you do, take a shot at it and then have an attorney look it over and give you comments. So.
Okay. Last question. When do homeowners' liabilities policies potentially kick in?
You have to check your specific policy, and most often they do not have anything to do with horses. I had a client who had a house and his barn on the same property. He had homeowners insurance and didn't think he needed, a different equine policy for the farm. And again, because of the Liability Act, well, someone got hurt and sued him. His homeowner's insurance did not cover him because it has nothing to do with horses. A lot of homeowners policies don't include, dog injuries. And every policy is different. I know they're big and they're onerous and they're hard to read. But if you talk to your agent, and say, well, does it cover this? Does it cover that? It's a good question about the homeowners policies, because like I have a client who is in an equestrian subdivision and there are bridle trails that go across the back of her house, and she owns, say to the middle of a canal, and then there's like a 30-foot bridle trail. Does her own homeowners liability cover if someone gets hurt? It may not. So check with your insurance company, and if you have a farm, you should get an equine comprehensive liability policy.
All right. Well, I think we are going to finish up there. Barbara, thank you so much for being with us and for
You're
sharing.
welcome. It was a pleasure. I hope that was helpful.
Absolutely. Yep.
There are still so many provisions that, I would recommend putting in contracts, but we can save that for another time, maybe. Or if anyone has any questions, I don't care what state you're in, please feel free to contact me, and, I can steer you in the right direction. So, and maybe refer you to an equine attorney in your state, or whatever. And thank you for all the thank yous. That's very encouraging. I appreciate that. Anytime. Eye-opening. I like that one.
All right. And for those of you that are still on the call, I will be sending out contact information for Barbara. So you will get that in the next couple of days. So.
Okay. And thank you so much. My pleasure.
Thank you. Thanks. Have a good night, everybody.
Okay. Bye-bye.